Imagine watching a witness take the stand, right? They put their hand on a Bible and they solemnly swear to tell the truth, the whole truth, and nothing but the truth.
Yeah, it's the ultimate dramatic peak of any courtroom show.
Exactly. But what you probably don't know is that the judge and the lawyers have already secretly conspired to ensure you the jury sitting right there in that box will only hear about like 40% of what that witness actually knows.
Oh yeah, juries are they are almost never trusted with the raw, unfiltered data.
Right.
We tend to expect trials to be these wide open rivers where the truth just pours out. But the reality is that the rules of evidence act as this highly engineered, aggressively guarded water filtration plant.
A filtration plant. I like that.
Yeah, I mean, every single drop of information has to pass through incredibly strict screens before a jury is ever allowed to swallow it.
Okay, let's unpack this. Today we are doing a comprehensive deep dive into the presentation of evidence, and we've custom tailored this journey specifically for you, the listener.
Right, whether you're currently, pulling your hair out studying for the bar exam, or maybe you just want the insider secrets of how trial evidence actually works in the real world.
Exactly. We are pulling directly from the GOAT Plus Grossman Enhanced Evidence Outline. So our mission today is twofold.
Yep.
First, we're going to deliver the black letter law, which is, the baseline rules of the game.
The foundational stuff.
Yeah. And second, we are decoding the insider knowledge. We'll highlight the GOAT tips, which are basically hidden traps and issue spotters, and the Grossman cues.
Those are the classic lecture tricks to help you master this topic. And this topic makes up a massive 1/4 of the multi-state bar exam evidence question, so it's huge.
Huge. So where do we start with this filtration plant?
Well, it requires a massive mental shift. Because before any of that dramatic cross-examination even happens, we have to understand the rigid architecture governing what gets said, who gets to say it, and who is allowed to hear it. So the very first barrier in that filtration plant is the foundational requirement for human beings taking the stand, which is personal knowledge.
Which, I mean, that seems obvious on its face, right? But GOAT warns this is a major threshold issue. A witness cannot just hop on the stand and start passing along like neighborhood gossip.
No, definitely not. The black letter law requires absolute personal knowledge. And the Grossman cue for navigating this on an exam is asking yourself, is this lay witness testifying strictly from what they actually saw, heard, perceived, or experienced firsthand?
Okay, so if the answer is no, what happens?
The testimony is blocked, period. But, human memory is notoriously fragile. A witness might have perceived something perfectly 3 years ago, but on the stand today, they just draw a complete blank.
Oh, right. And that introduces the rule on refreshing recollection. And the black letter law here is actually remarkably broad, right? Like a witness's memory can be refreshed with almost anything. A written document, an object, a sound, a photograph.
Yeah, almost anything.
GOAT calls the trap here on exams outrage bait. He points out you could use a police report, a highly personal diary, or even a specific smell.
Like uncapping a bottle of the specific perfume to jog their memory.
Yes. But wait, if they are staring at a police report on the stand, why doesn't the best evidence rule block that? Like, shouldn't the actual document have to be formally admitted into evidence before they can talk about it?
Well, what's fascinating here is understanding the underlying mechanism. The best evidence rule does not apply because the document itself is not the evidence.
Oh, interesting.
Right, the refreshed, revived memory inside the witness's brain is the actual evidence. The physical item is just the spark used to, jumpstart their brain.
That makes a lot of sense. So refreshing a witness's memory is basically like showing someone a menu to remind them what they ate. But you can't just read the menu out loud to the jury.
That is a perfect analogy. And to maintain fairness, the opposing party has the right to inspect whatever that refresher was. They can use it on cross-examination, and they can even introduce relevant portions into evidence themselves if they want to show the jury exactly what prompted this miraculous sudden burst of memory.
Right, like, look what they needed to see to remember this. But Grossman draws a massive red circle around this concept, warning listeners not to confuse refreshing recollection with recorded recollection.
Right, they sound identical, but they are so different.
Recorded recollection is a completely different concept. It's a hearsay exception where a document is actually read into the record because the witness's memory cannot be refreshed.
Exactly. But let's say someone tries to break these rules, like they try to sneak bad evidence past the filter. The opposing lawyer has to stand up and object. The black letter law demands that objections be both timely and specific.
And timely means doing it at the earliest reasonable opportunity, right? Usually before the witness answers the bad question.
Yes. And specific means stating the exact, legal, ground-like relevance, hearsay, character evidence. Because failing to do both generally waives the issue on appeal. You can't complain about a dirty filter later if you didn't point it out when the water was flowing.
That is such a good way to put it. But Goat points out that the flip side of an objection, the offer of proof, has been heavily tested recently. Because if the judge wrongly shuts down your brilliant piece of evidence, you don't just, sit down in defeat.
No, you definitely don't. Grossman lays out a stark contrast here. An objection is what you do to keep bad evidence out, but an offer of proof is what you do to preserve why excluded evidence should have come in.
Right. You are basically packing a time capsule for the appellate court. An offer of proof puts three distinct things on the formal record outside the presence of the jury. It's what the evidence actually is, how it relates to the case, and the legal argument for why it's admissible.
Exactly. You are ensuring the appellate judges can see exactly what the trial jury missed.
Okay, so if the judge is acting as the manager of this filtration plant, their very first job is checking the raw material itself, right? Deciding if the human being on the stand is even qualified to open their mouth. That is the threshold of competency.
Yes, and the black letter law for competency is actually pretty forgiving.
Yeah.
You just have to take an oath or affirmation.
And the bar is incredibly low. Grossman points out that you should not disqualify a child just because of their age. Wait, let me stop you there. If a child is like 5 years old, they don't understand what a legal oath is. They don't understand the constitutional penalty of perjury. How can they possibly pass a competency test?
Because the legal test isn't about understanding the complex mechanics of perjury.
Okay.
The only test is whether the child understands the fundamental duty to tell the truth and can accurately articulate the difference between a truth and a lie. If they understand that lying is bad and gets them in trouble, they are competent to testify.
Wow, okay. That makes the dead man statute stand out even more. Goat points out this specific rule as a high-value trap. So a dead man statute bars an interested party from testifying about communications with a deceased person in a civil case.
Yeah, and the logic here is pure self-preservation for the deceased. If you claim you had a handshake deal with a guy who just died, the law won't let you testify about it because the dead guy isn't there to defend himself. He can't call you a liar.
It levels the playing field. The major Goat tip for the bar exam is that there is no federal dead man statute. However, if you are in federal court on a diversity case, meaning a federal judge is applying state law for a civil dispute, a state dead man statute might absolutely apply and block that testimony.
Right, so we have our competent witnesses, but there's a massive divide in how they are treated. Grossman says lay witnesses offer ordinary perceptions, while experts offer specialized knowledge.
And the absolute giveaway for a correct bar answer regarding a lay witness like the true Goat signal is the phrase rationally based on the witness's perception.
Spot on. If a lay witness is estimating a car's speed, or noting that someone seemed intoxicated, or recognizing a familiar handwriting, it must be rooted in their rational, everyday, first-hand experience. They cannot offer a specialized legal or scientific conclusion.
Experts, however, require a demonstrated foundation of knowledge, skill, training, experience, or education.
But there are brutal reading comprehension traps here. Grossman warns that just because someone is a world-class expert in topic A, that does not make them an expert in topic B.
Right, you can't have a brilliant orthopedic surgeon testifying about the structural integrity of a collapsed roof.
Exactly. And in criminal cases, an expert faces a major roadblock. They cannot state whether the criminal defendant possessed a specific mental state that is an element of the crime.
The law maintains a very strict mental state exception. If a crime requires specific intent, like premeditated murder, a psychiatric expert can testify all day about the defendant's mental disease or defect, but they cannot cross that final, ultimate line.
Right. They can't explicitly state to the jury, therefore, the defendant did not have the required intent to kill. The final conclusion on mental state belongs entirely to the jury.
Which brings up a fascinating paradox about who decides what. Because the black letter law states the judge decides questions of law and admissibility, while the jury decides credibility, weight, and factual disputes. Admissibility equals judge, weight equals jury.
Right.
But Goat highlights that when a judge is deciding those preliminary admissibility questions, they're actually allowed to consider hearsay or affidavits. That sounds like a complete paradox to me, like the judge is actively breaking the rules of evidence in order to enforce the rules of evidence.
Well, this raises an important question about trusting the legal professionals. It is a paradox, sure, but it is deeply embedded in the black-letter law. When deciding preliminary facts, meaning the judge is simply determining if a piece of evidence meets the gateway standard to eventually be shown to the jury, the judge is not bound by the rules of evidence, except for the rules of privilege, of course.
Okay, so why do we allow that?
We allow this because the judge is a seasoned legal professional. We trust them to look at hearsay, evaluate its reliability for a gateway decision, and not be unfairly prejudiced by it in the way a lay jury might be.
Here's where it gets really interesting. We've talked about human witnesses, both lay and expert. But sometimes the legal system decides we don't need a witness at all. Sometimes the law takes a shortcut.
Oh, judicial notice.
Yes, judicial notice allows a court to accept a fact as true without requiring a single piece of evidence.
But the filter is still highly active here. The fact must be generally known within the jurisdiction, or it must be capable of accurate and ready determination from unquestionable sources. So you don't need to call an astronomical expert to the stand to prove what time the sun set on October 14th of last year.
Right. But GOAT gives a massive warning here. The judge's personal knowledge is strictly prohibited. If the judge happens to personally know that a specific suburban intersection always floods when it rains because, they drive through it every day, that does not count.
No, it has to be an unquestionable objective source. And the way juries handle judicial notice changes based on the courtroom. In the civil case, the jury must accept a judicially noticed fact as an absolute conclusion.
But in a criminal case, the jury may accept it, but they are not legally required to.
Which perfectly introduces the concept of presumptions. Grossman provides an excellent framework for keeping this straight. He divides it into production and persuasion.
Okay, break that down.
Sure. Production simply asks who must produce the initial evidence to get the issue moving in court. Persuasion asks how much proof is ultimately required to win like preponderance of the evidence in a civil trial, or beyond a reasonable doubt in a criminal trial.
Think of a presumption like a game of tennis. The law automatically serves the ball into the opposing party's court. GOAT loves the mail presumption for civil cases. If you prove a letter was properly addressed, stamped, and mailed, the law presumes it was received. So the defense now has to hit the ball back over the net. They have to produce evidence saying they never got it, or they automatically lose that point. But GOAT explicitly notes that mandatory presumptions are never allowed in criminal cases. So the state is never allowed a head start when trying to prove a crime.
If we connect this to the bigger picture, the reasoning is anchored directly in the Constitution. A mandatory presumption in a criminal case, where a judge commands a jury, if the prosecution proved X, you must presume Y is true, that violates a defendant's fundamental due process rights.
Because the state has the burden, right?
Exactly. The prosecution bears the constitutional burden to prove every single element of a crime beyond a reasonable doubt. The state is never allowed to use a legal shortcut to bypass that heavy burden.
Wow, okay. So with all these rules in play, a trial moves incredibly fast. Someone has to direct the traffic so it doesn't devolve into just a shouting match. The black letter law dictates that the court actively controls the mode and order of examining witnesses.
And the goal there is to make it effective for truth-finding, to avoid wasting time, and to protect witnesses from harassment.
And those logistical courtroom decisions are heavily protected on appeal, right? They are reviewed under the abuse of discretion standard. GOAT reminds us that this standard means the appellate court will not overturn the trial judge's decision unless the judge acted completely arbitrarily or irrationally.
Yeah, it's a very high bar. The judge also strictly enforces the scope of questioning, which constantly narrows as a witness stays on the stand.
Right, it's like a funnel. Direct examination is the broadest. Cross-examination is strictly limited to the subject matter brought up on direct, plus credibility. Redirect narrows further, limited only to what was raised on cross. Recross is limited to redirect. It just gets tighter and tighter.
But GOAT's major tip is that impeachment, which is attacking a witness's credibility, is the one permanent exception. It can enter the conversation at any stage of the funnel.
The court also controls the form of the questions themselves. The general rule is no leading questions on direct examination, but they are welcomed on cross-examination. Grossman defines a leading question simply as one that suggests the answer to the witness.
You are putting words in their mouth and asking for a yes or no confirmation.
There are preliminary exceptions on direct for, like background matters or young children, but my absolute favorite GOAT tip involves a hostile witness. If you call someone to the stand and they unexpectedly turn on you, becoming biased, hostile, or aggressively evasive, you can ask the judge for permission to switch your tactics.
Yes, the judge can allow you to use leading questions on your own witness, essentially treating them as if they were on cross-examination.
Now, beyond the questioning, the judge also controls the physical room through the exclusion of witnesses. At a party's request, the court must order witnesses excluded from the courtroom so they cannot sit and listen to the testimony of other witnesses.
Right. It prevents them from subtly aligning their stories or changing their testimony based on what they just heard.
But wait, let me challenge that for a second. Based on a specific goat tip, if you have a witness who has a horrific criminal record, maybe a documented history of fraud or perjury, shouldn't the judge just permanently exclude them from the courtroom to protect the absolute integrity of the trial?
It seems logical, but actually, no. Goat points out this vital distinction. Bad character or a criminal record does not make a person legally incompetent to testify. You do not exclude a witness from taking the stand just because they have a bad record.
Okay, so what happens?
That flaw simply becomes highly effective ammunition for the opposing side to use for impeachment, which we are about to discuss.
Which brings us to the absolute crescendo of this deep dive, tearing down the witness. If someone is sitting in that chair and you know they are flawed, how do you legally deconstruct their testimony? It sounds like impeachment is a very specific toolbox.
It really is. The core rule of impeachment is that it attacks the credibility of the witness currently testifying. Grossman's tip is crucial here. This is about the witness hat, not the defendant's character.
The witness hat.
Right. If a criminal defendant chooses to take the stand, they put on the witness hat and they open themselves up to being attacked just like anyone else. The law provides a highly categorized toolbox for these attacks.
So if you want to show they are just mistaken, you pull out a sensory deficiency like poor eyesight, deafness, or the fact that they were heavily intoxicated during the event. Goat points out that is incredibly effective at showing the jury the witness is just wrong.
Exactly. Then there is bias, showing they have a motive to lie.
And bias is such a powerful tool, it can override rules that normally exclude evidence. Ordinarily, you are strictly forbidden from bringing up liability insurance during a trial to prove someone was at fault.
Right, you can't just say, they have insurance, so they don't care.
But if a witness works for the defendant's insurance company, you can suddenly bring up that insurance policy to show the witness is biased and financially motivated to save their employer money.
That's a huge exception. You can also use prior inconsistent statements. Grossman tells you to look for the stark contradiction, like, the witness said A last year, but they are testifying B today.
Normally, bringing up that past contradiction is only used to make the witness look completely unreliable. It is purely for impeachment. But Goat highlights a specific wrinkle. If that prior statement was given under oath in a formal proceeding, like a deposition, it becomes substantive evidence.
Which means the jury isn't just using it to decide if the witness is a liar. They are legally allowed to rely on that past sworn statement as the actual literal truth of what happened.
Wow. But let's slow down and look at the most aggressive tool in the box, which is convictions. If you want to prove someone is a liar using their past crimes, the black letter law divides this into specific buckets.
4 buckets, right.
The first bucket is crimes of dishonesty or false statement. This is fraud, perjury, embezzlement. Those come in automatically. It doesn't matter if it's a felony or a misdemeanor. There is no weighing test. The jury hears about it.
The complexity arises in the second bucket, which involves felonies that do not inherently involve dishonesty. Think of a violent assault or drug possession. To get these in, the judge must apply Rule 403.
And Rule 403 is the ultimate balancing test. The judge has to weigh whether the probative value, meaning how useful the evidence is for proving a point, is substantially outweighed by the prejudicial effect, which is the risk that the jury will just get inflamed and make an emotional decision.
Right. And GOAT uses a time limit as a massive memory hook for these felonies. If the conviction is over 10 years old, the probative value must substantially outweigh the prejudicial effect.
So it is incredibly difficult to get, like, a 12-year-old shoplifting conviction into a current trial.
Exactly. But if the conviction is under 10 years old, you have to look closely at who is sitting on the stand. If it is any ordinary non-defendant witness, it falls under the standard Rule 403. It comes in unless the prejudice substantially outweighs the value.
But if it is a criminal defendant witness on the stand, the standard shifts. The probative value must explicitly outweigh the prejudice. We require that special protective standard because the danger is so incredibly high, right?
Yeah, juries are dangerously tempted to convict a defendant simply because they hear they have a criminal past. rather than evaluating the actual evidence of the specific crime they are currently on trial for.
But what if the witness did something terrible, like, I don't know, lie on a resume, but they were never actually arrested or convicted of a crime?
The black letter law permits you to ask them about specific instances of bad conduct on cross-examination, provided it directly relates to their truthfulness. But GOAT warns you of a massive procedural trap here. You are completely stuck with their answer.
Stuck with it.
Yeah. If you ask the witness, did you embezzle money from your last job? And they confidently say no, you must accept that answer and move to the next question.
You cannot bring in extrinsic evidence, meaning you cannot call their former boss to the stand or wave a forged bank document around just to prove they lied about the embezzlement.
Right. The court does not have the time to pause the main trial to hold a mini-trial about a past job.
That makes sense.
And here is one of the most mind-bending applications of that entire impeachment toolbox: impeaching a hearsay declarant.
Oh, impeaching a ghost.
Exactly. Sometimes a statement legally bypasses the filter and comes into evidence through a hearsay exception, even though the person who originally spoke the words is nowhere near the courtroom.
Goat calls this attacking a ghost. If a hearsay statement gets in, you are allowed to attack that unseen, out-of-court declarant exactly as if they were physically sitting on the witness stand.
Yes, you can introduce their past perjury convictions, their financial biases, their prior inconsistent statements. You can completely tear down a ghost.
But Goat also warns about a trap regarding rehabilitation. If your witness gets attacked, your instinct is to build them back up with a prior, consistent statement. Do not try to rehabilitate a witness who hasn't actually been attacked yet.
Right, you cannot preemptively bolster their credibility. The attack must happen first.
We have covered a massive amount of ground today. By understanding these concepts, from how we get evidence in past the gatekeepers to relying on judicial shortcuts to how the judge commands the room and the exact tools used for impeachment, you now hold the ultimate cheat code for the bar exam and the courtroom.
But before we close, I have to drop one final piece of black letter law that completely reframes this entire deep dive.
Okay, let's hear it.
After everything we've just discussed, all these incredibly strict, highly engineered rules, they don't even apply everywhere.
Wait, really?
Really, the federal rules of evidence generally govern civil and criminal trials in federal courts. But Grossman and Goat explicitly note they do not apply in grand jury proceedings, preliminary probable cause hearings, sentencing, or search warrant proceedings.
So what does this all mean?
It means the rules are deeply context-dependent. When a judge is determining a sentence or a grand jury is deciding whether to issue a criminal indictment, the strict filtration system is simply bypassed. They can legally look at hearsay and unauthenticated evidence that would never survive a normal trial.
Which leaves you, the listener, with a final question to ponder. We started by exploring how a trial is a heavily guarded filtration plant designed to hide the raw data from a jury. But if human rules of evidence are this flawed, this full of paradoxes, and this heavily engineered to manipulate exactly what 12 ordinary people hear, what happens when technology catches up?
That's a scary thought.
Right. If an AI algorithm eventually enters the justice system, capable of calculating the statistical reliability of a witness's memory in real time, will we even need these strict human rules of evidence anymore? Or will the algorithm just replace the judge and become the ultimate, inescapable filtration plant? Something to think about the next time you watch a courtroom drama.